need the federal government, but many can, and they're creating obstruction because really they can't overcome if a lot of states do this. And I think you'll see this going around. And this is in Section 1 a states' rights issue, and you were claiming that very clearly right there. If you look in Section 2, I'll kind of summarize it. It's a person who has the Georgia weapons carry license in another state who recognizes, the state that recognizes our license can carry for 90 days after they become a resident. This is allowing for the carry while in the process of gaining a Georgia weapons carry license with their old current state's permit as a license. We'll turn it over to page 3. This is one of these unfortunate things that we had to deal with. You look on line 69. This is a little bit of hunting and fishing information. This is just there to allow knives while hunting and fishing. And just interesting thing we needed to do. Line 70, not required by law. Could be a number of things. Could be by age, property location. That would not require them to have one. People always like to educate folks too. The definition of a knife is a cutting instrument with a blade that's greater than 5 inches with the handle. And it can be used for offense or defense. Okay, Section 3. We jump on down through there. We're in 1611-127. This is carrying in unauthorized locations. And we're just going down through here. We're again clarifying the code section of what leased government property is and what private property is. And you look at, this refers back to line 78, just really trying to clarify that for people that need a little bit of clarification. I heard a snigger, I believe, or a brief high sigh in the background. Look on line 95. Just look there. Why it's in there is this change will still allow for a church to decide, but will not immediately criminalize a person or fine them for making a mistake by entering a church. Like in their trespass law, they'll have the opportunity to retreat under the trespass statute of 16:721. They must leave, and if they don't, they'll be treated as such. Okay, so we flip our page. Section 4. This is current law, and we're talking here about folks who are going to be in the school safety zone, and that's in 126 through 127.2, and it's the list of people while in performance of their duties to and from Route 7 groups. What we want to make sure is that someone who is off-duty law enforcement will be able to allow to carry in the school safety zone. Also, I think these people are trained. You can look at the list of these folks. I think everyone will agree that these folks are here to protect. It also allows them to protect themselves in case they run into a mad mama at the basketball game, I always thought. In Section 5, they're on 125. Just real simple. We think about guns, and we hear a lot of talk about safety. And Chairman Powell and I were going over this bill. We really wanted to add one part to simply allow, and I think this is what some probate judges thought they might not be able to do, to provide printed information on gun safety. And the judge shall do it, as it says, really use their direction. The source of the material would be displayed. If you flip over on 4, we're going to look at instructs the DNR to maintain, and they do that now, and talk about gun safety. And I think that's one of those good things we're looking at. You'll see an amendment that we'll make in a few minutes on 136 that will just make sure we clarify it, that they're not making them do. They do that now. We're just clarifying using their words. Look on line 160. House Bill 60 required the surrender of a Georgia weapons license in the event the license holder was convicted or now adjudicated that made them ineligible to have a license. We're going to clarify that in a few minutes with other further amendments. We've got some judges here to help us do that. Flip over on to next page. It'll be page 6. Life changes. And you've got a Georgia weapons license that lasts 5 years. And this is going to allow those to get a license, though they may be after a divorce or separation, or they're a new person, an address change. You're still the same person, so it's going to allow you to receive a replacement license if you're within the time period. I think it says 60 to 90 days there. So, but what it doesn't do is it doesn't extend the length. So if you've got 2 years left on your license, you'll still have 2 years left. The fee that it talks about in line 186 is $6. Okay, section 6, we're revising 130. It's that, if you remember the code, section 130, as you look right down through there, is the big, broad exemption list. On line 198, you'll see the change retired agent of the GBI. 224, we're still in 130, the exempt list. It's that long list we keep adding to. I think some of us one day sure want to see that the Georgia weapons license holders may be added to that list, but not today. This is some addition from the Senate that's working on this also. Talks about federal retirees. This is a description of a federal retiree, and we just, our good legal counsel helped us put that in our code. Look on 242. This is an important part we'll talk about, and it will change from your sub to what I have. And we're talking about here in 241. Oh, no, it's not. We're not there. It does change. And Mr. Chairman, I didn't get a sub to take with me to kind of go over that part of it. If you could, you got one, Julius, for me? What we became aware of, the bills evolve over a few weeks, is that, this is, wait a minute, I'm on the wrong spot, am I not? About our people being entering courthouses. Yes, we're right there. That law enforcement is entering some courthouses unarmed. That means they're having to walk up from their car to a courthouse, in some instances unarmed, and mixing with the people that they're going to testify against. And I think so. We just looked at that as an issue waiting to happen, and I think we've addressed that very clearly here, and that we want them to be allowed in. And we're going to kind of put in here, as you see, Julius, you'd help me where we talk about the storage. Such facilities, okay, on line 262, that they will store law enforcement's weapons past their security zone. And I think that's what big change, but I think it's going to ensure the safety of our law enforcement as they come and go, because I believe that's our number one issue. Section 7, this is just a definition to clarify what airports are and how that they are identified. It does show that they're big, that they're going to have TSA security in those airports. And this is a good definition, it's a federal definition. And those airports that meet this requirement have TSA security for entering airplanes. Those that don't meet this definition do not. And so therefore they're public property, and can't be, someone with the Georgia weapons license can't be prohibited from carrying in that area. Section 8. We're going to strike Section 8 at this moment. It's going to take it out. We'll do some ongoing discussion for next year. And that's the selling of weapons. We all know it's very important. In Section 9, this is an interesting thing. I think this is going to be one of these bipartisan issues. When someone is put on the federal prohibited list, they stay on it. But at some point in Georgia, allowed those people who are on that prohibited list, and if you can look up above on 356, 357, 358, kind of describes those people. For some reason, after 5 years, those people spin off, so they're not on the Georgia list. And it's for us to line up with federal on this one. We're proposing that they stay on that list, but they do have the ability, just like they do on the federal side, to come off of it. It's a pretty detailed list. We've worked on that. I think there may be a amendment or two from the judges just to make sure we clarify that so that we're getting the right people and not grabbing the wrong people. And I think we sat down, we really went over this thing to make sure that those people who should be on that list stay on that list. And you look in the next page or two, it really kind of goes through it. One amendment I know that'll come through is line 405 on my copy. It's probably different on yours. These will be an open proceeding, not a closed proceeding. And in section 10, you know, sometimes somebody in your own neighborhood has a suggestion for a change in the bill. And it's probably the simplest part, but probably, I think, most effective. Because when we talk about safety and weapons, I think we want to encourage people for training. And if you look at lines 439 through 447, if you instruct, educate, or train a person the safe and proper use of a firearm, you'll be immune to civil liability. And that's just simply, if I train you, any committee member, to be safe, you go out 6 months later, commit some atrocity, you know, they're not going to be able to come back and sue me just for training you. And I think this is one of those things the instructors want, and just for their protection. And I think you'll further instruction and more gun safety. I know that's a lot, but I think you'll see this isn't one of these got you, we're going to sneak something by you kind of bills. Just a lot of thoughts went into it. And I'll be glad to answer questions or, you know, kind of lead you through it again. But we will have a number of amendments that will come through, Mr. Chairman.
Any questions from the committee? My gosh, we're all behaving today. All right. Representative, and to the members, I have the amendments here, and I'm going to have to read these out to you. And these were proposed amendments from the Council of Superior Court Judges, Judges Crawford and Goss. If you look on Section 5, go to line 160, 161, and if you would strike subject to an adjudication and replace that with otherwise adjudicated in a manner. If you would just replace that.
Mr. Chairman, is that matter or matter?
Matter.
Matter. Okay, thank you. Yes, sir.
Otherwise adjudicated in a matter.
Okay.
Second change, go to Section 9. Excuse me, strike Section 8 in its entirety. We may be dealing with this if we can find some friends in the Senate. But if not, we'll just have to work with this. Section 9. On line 374. Insert after hospitalization and before and any person, and insert the probate court that issued the involuntary commitment. On line 393, strike 30 and replace with 60. You might want to clarify that, because I'm looking at
LC. They're using the LC.
Did they prepare this?
Yeah.
All right. Bear with us a minute. We're about to put it in sync. The judges prepared their amendment from a separate LC number.
Would it be on line 444? On the sub? Yeah, okay.
That is correct.
30 to 60.
Yes, sir.
No, actually, I think it's 421. I think they run it.
421.
Time for the hearing.
I believe that'd be line 421. Council thinks it's
Oh,
60 days in receipt of the petition.
okay. Yes, sir. That was the first 30 I saw was on 444.
Are the Superior Court judges in here today?
Yeah.
Y'all were working from a different LC number. While we're getting these amendments perfected, I'll go ahead, if there's no questions from the committee, I'm going to go ahead and call some folks up. Lizzie Stallman.
Mr. Chairman, while we're doing that, I'd also like to look at line 136.
All right.
And strike the word gun safety and put hunter education.
All right. Ms. Stallman?
Can you see me, Chairman?
I can. Welcome.
Good. Lacey Stallman with Gun Sense Georgia, Outcry, and the League of Women Voters. I was actually here for an event this morning with the League, and I got word that this bill had been added to the agenda today, so furiously grabbed a copy and did the best I could to dissect it, not being a professional or getting paid to do this. I ran into Chairman Powell outside when he was smoking on a stogie, and he greeted me warmly, and I said SSDD, and he didn't know what that meant, but I filled him in a little bit later. I know the inevitable outcome of this bill in this committee, but I really needed to get a few things off my chest about some of the problems that I see with it. Congratulations, you tweaked HB 60 in half the pages. Went from 26, now we've got a 13-page bill. Really hard to get through. So let's go on to this. Section 1, adding Second Amendment language. Did you really need to do that? Yesterday's floor debate, Rep. Bob Trammell quoted Justice Scalia and Thomas Jefferson, and Chairman Powell and Rep. Jaspers. I could see you from the gallery, and you looked a little uncomfortable with everything he was saying about exceptions to the Second Amendment.
Well,
Quite
frankly, what I was uncomfortable with was the fact that his grandmother shot a quail with a rifle.
Oh. Okay. Well, she's a good aim, I guess. Section 2, reciprocity, covers up to 90 days after residency, and then in lines 59 and 60 are the words "as soon as practical." Do you really need that if you say up to 90 days? Doesn't it mean up to 90 days? I mean, who's going to be reinforced by that, really? I don't know what that means. It's really ambiguous. And what if, hypothetically, a carrier in another state who had just committed his first crime, because we know that some people do snap and commit crimes, comes here, moves here to flee prosecution? Are you really going to give him 90 days before he even has to obtain a carry permit? He's probably not going to, but he's got that 90 days, and he hasn't renewed his permit since he committed the crime, and nobody knows he committed it.
If I might answer a couple of these
Sure.
as you go along. In the real world, if somebody's committed a felony in another state and has fled to Georgia to avoid prosecution, do you really think they're going to go to a probate judge's office to re-up their gun permit?
That's exactly what I'm saying. We're arguing the same argument.
No,
He's
ma'am.
committed his first
No, ma'am.
crime.
We're talking about people who come into the state that have a legitimate background permitted permit in another state. They've moved into the state of Georgia, It takes a while, but they'll have 90 days. Their old permit will stay in effect for that 90 days until their new permit is enacted.
Okay, I have some comments at the end, and I'll clarify that. All right, Section 3, private entity leases public property and invites the public. You have to allow licensed carriers. Is that correct? Is that correct? Okay. Let's say hypothetically, I'm an artist, which is a real hypothetical because I have no creative ability whatsoever. I want to lease the Piedmont Park bathhouse for a show, open to the public because I'm a starving artist and I need as much money as I can get. The way it reads, lines 81 through 83, change private property to exclude leased public property. Is that correct?
Yes.
Okay. And a gun carrier can only be ejected for criminal trespass. So I don't quite understand whether it's for one day or a weekend or 3 months or whatever. Isn't a business, private business, leasing space considered private property? Is this what you want to change in this bill, obviously?
Obviously.
Okay, so I read that correctly. Okay, let's go to places of worship. This reminds me of the oops, I forgot provision at the airport. You can retreat from the TSA line and you can put your gun back in your car. My place of worship has a sign on every door that prohibits weapons into it. So now somebody can come in, they can clearly read that, and yet they have a second chance to violate this private property rules and get away with it. I guess if somebody's legally blind and can't read the signs, and of course we all know now that in Georgia a legally blind person can obtain a concealed carry permit. And before you attack me for being disability phobic, 2 things you need to know. My best friend is a paraplegic and a gun owner because she can't run. And another killing device, an automobile, requires a vision test with every renewal. Okay. Bravo on the distribution and posting of safety info. With not 1 millisecond of training required in Georgia, at least that they can read that. But for the visually impaired, are you going to do that in Braille and large print? I think it should be done in Braille and large print. Okay. Rep. Jaspers skipped over one thing that I thought was pretty telling. In lines 143 and 144, cutting to a third, from 30 to 10 days, the amount of time law enforcement has to report on questionable applicants. Isn't that a further burden on those who are assigned to serve and protect, like these gentlemen in uniform? And no delays allowed in processing permitted in the probate courts makes carry licenses priority over other important business and places more stress on the courts, who are generally pretty overloaded anyway. Okay. Lines 362 to 403. I like that you threw a bone at Senator Parent and incorporated her bill into this. Okay. Again, with such short notice, I haven't really had time to go through this fully, but I'd like to make a few parting remarks. Does anybody recognize the names Curtis Reeves and Chad Olson? Okay. Curtis Reeves is a 71-year-old retired police captain in Tampa, Florida. Chad was a 43-year-old husband in Florida and father. Chad was texting his babysitter during previews at a movie theater in Tampa. Reeves started a verbal argument. Olson was armed with popcorn, Reeves with a gun. Chad's dead. Curtis will probably be in prison till he's 96 if he lives that long. All over a silly argument and a good guy who had a gun who snapped. Anybody familiar with Jason Dalton? He's been in the news lately. He's the Uber driver that a couple of days ago killed 6 people and injured 2. In order to work for Uber, he had to pass federal, state, and county background checks. Showed no criminal record whatsoever, the same as what you guys do for a carry permit. Kalamazoo, Michigan, he snapped. The premise that begins every argument that you say that you have about good guys with guns and passing background checks just doesn't hold up to me. Thank you for your time.
Thank you. Any questions of the lady from any committee members? Thank you so much. Ronald Barrett.
I'm actually died 76.
I beg your pardon?
Not this bill, another bill.
Oh, I'm sorry.
That's okay.
Judge Goss.
Thank you, Mr. Chairman, and I'll be very brief because you've already gone over our proposed amendments. We did not have the sub, so we were not able to line up the page and line. The one thing I did want to point out in Section 9, where we were talking about various offices and agencies that had to be given notice of a petition to reinstate, we added in the language to give notice to the probate court that actually issued the original involuntary commitment. We left off the word order. It should say involuntary commitment order. And the reason behind that is the probate court judge would be the office that the district attorney and the superior court would be most likely to get some baseline information from out of their file. So we felt like it would probably be prudent to give them notice. I'll answer any questions if there are any.
Any questions from the committee members?
Thank you, Mr. Chairman.
Thank you, Judge. Always a pleasure having you come up from Albany. Todd Edwards.
Thank you, Mr. Chairman, members of the committee. I'm Todd Edwards with the Association of County Commissioners. I want to first of all thank the author and the committee for agreeing to take a further look at Section 8. The majority of our concerns involve provisions within that section, so no need to go over those. I did want to bring up one point of which you'll hear we've heard from our members was a concern. I know and we've asked you over the years to provide some clarity over the instance in which a government building, a government-owned building, is leased to a private entity, and we were never quite sure if and when you could prohibit guns from that building. If it was a government building, then you could do it via a screening by security personnel, but these arenas, the Macon, I think is the Civic Center or Convention Center, that's not a government building. It doesn't fall into definition. If it's a private, then the entity could decide whether or not to allow guns into the events. The way I read this is it does lend some clarity to what this building is, but in my understanding, and I'm happily corrected if I'm wrong, is that because it's not a government building, you can't prohibit guns through screening and security. It's not a private building, so you can't have that individual or that group make a decision. So this was effectively preempt the government or the private entity from prohibiting guns into that arena, whether it be a concert, and I'm not sure if the Dome is a state-owned facility, at least to other entities, but I think you will hear from our members' concerns, particularly for various concerts that they have at these arenas, that under no circumstances can they prohibit weapons. And if I'm wrong, please correct me if I'm not, and it may be in the intent. I just wanted to go on record stating what we'll be hearing from our members should this legislation pass. With that, I have no other comments, and I thank you for the opportunity to speak before the committee.
Yes, sir.
Callan, who owns the Macon Coliseum?
I really don't know. Those are the ones we've got the calls from, and we did have that discussion. Is it
not true it's by an authority?
It may well be.
It's a governmental authority?
Yes, sir.
And within that, it does fall into House Bill 60 that it's a government building. If they want to exclude weapons, they would do like any other government building and provide security to make it a gun-free zone or a gun-prohibited zone inside that building.
If that's the case, I'm happily corrected. As I stated, that was my read of the bill, and I haven't had feedback from our attorneys yet on that.
Thank you.
All right. Any further questions of Mr. Edwards? All right. Thank you, Todd. We have Justin Kernan from GMA. Justin?
Yes.
You want to speak on both 1060 and 976?
Absolutely.
All right.
Well, thank you very much, Mr. Chairman, for your time. Thank you, members of the committee. And I'll echo what Todd Edwards with ACCG stated. Most of our concerns were with Section 8, and we appreciate the author and the committee taking another look at it and taking a little bit more time to address some of those concerns that we had in that section. So that's all we have today. Thank you.
Thanks, Vernon. Justin, now, does anyone else out there wish to be heard? Yes, ma'am. Well, come right on up.
Mr. Chairman, members of the committee, my name is Elizabeth Apley, and I represent Presbyterians for a Better Georgia. We believe that all life is sacred, and that motivates our concern about working to reduce gun violence in this state, and that is the reason for my coming here to speak with you this afternoon. Section 3 does seem to change drastically the law relating to public property leased to private entities. I understand that this issue is being litigated with the Atlanta Botanical Gardens. They lease property from the city of Atlanta. They contend that they have the right to exclude people carrying weapons, and I believe that issue is in litigation, and that it would have application in a number of circumstances where private people believing themselves to be in the posture of private property owners, notwithstanding the fact that they are leasing the property from a governmental entity, wish to have the right of a property owner that's private to exclude persons with weapons. So we ask you to please consider that. In section 5, we would urge the committee and the author, and I apologize, I have not had the opportunity to go directly to the author, to consider this gesture of having probate judges having the option to offer gun safety information, that it would be a much better use if we could change that may to shall and require that the probate judges provide gun safety information. We'd also, I understand that the author has proposed an amendment on line 136 to strike gun safety and replace it with hunter education. We would ask him to leave both in so that there could be a link on the Department of Natural Resources website to both hunter education and gun safety information that people could avail themselves of. Mr. Chairman, I do have concern on line 160 with the striking of the language involved in any manner. Obviously, that's much broader than the proposed language, which would limit the court's ability to act to those persons who are otherwise adjudicated in a matter. We believe that what the court's discretion allows for here to inquire whether a person is a holder of a weapon, to notify the court that issued that permit, is a good and safe process, and that we do not want to see this committee narrowing the court's exercise of discretion when you have a person involved in a matter. It should be noted with regard to line 242, at least, are you all working off a sub? So I apologize if I'm giving you bad line numbers.
We're working from LC0762S.
Okay, I apologize. I have only the original as filed. I'm looking at line 242 within section 6 that deals with the right of retired law enforcement officers to with proper identification to carry. I want to draw to the committee's attention, at least in the original version, that that was amended to include courthouses, a location where previously that was not permitted. And finally, Mr. Chairman, in Section 9, we commend the author's efforts to revisit the automatic elimination of the record after 5 years. We appreciate the extension of the time for the DA to make that case to 60 days. We do think that it is a good improvement. And I apologize, I wanted to go back. I did want to underscore this issue that was brought to your attention about reducing the time for the reporting of the GCIC information. I believe that that's in Section 5 of the original bill. Am I correct? And so what we have there in Section 5 is a reduction of that time from 30 days, as it is now for the GCIC or law enforcement to provide the information to the probate judge, to 10 days. In addition, that language, at least at the end of subpart 4 on lines 157 through 159 on the version I'm looking at, prohibits the court from extending the time for any reason. It's particularly important that you note that when a law enforcement agency fails to return a report under existing law, a court could interpret that as meaning there is no derogatory information to be reported. And so a judge would have no way of knowing after the passage of 10 days whether there is no information to report or the law enforcement agency was just unable to meet that very fast timeline. So we're very concerned about that. And we appreciate the opportunity to speak with you. I do apologize again to the author. Under the best of circumstances, I would have come to him first.
Very good. Any questions from any of the committee members? No? All righty. Thank you, ma'am. Now, do we have anyone else who wishes to be heard on House Bill 1060? Yes, sir. Mr. Henry.
Thank you, Mr. Chairman, Mr. Jaspers, committee members. I'd like to thank you for bringing this bill forth. I am the executive director of GeorgiaCarry.org, and we back this bill 100%. We think that it's a step in correcting some of the problems that we have right now with the existing laws that we have, much as we did in HB 492 last year. That's all I have to say.
Any specifics that you wish to address? Or
well, no, other than the fact that when we're talking about cutting the time frames from 30 days to 10 days, those fingerprint checks are done electronically, and it only takes a matter of seconds to send those off and get them back. There's no reason why there shouldn't be back to the sheriff's office within 10 days.
Are we thinking that this could possibly have been the ideas between clarifying this might have been because in some jurisdictions where we thought that maybe there was a downtime from the probate office, but we found out that a lot of times it was a downtime of the agency providing the background check, that sometimes they had other priorities other than dealing with someone's Second Amendment rights.
Well, it was definitely that way back when we were doing ink prints. I don't believe it to be that way now. The GBI can tell us, Vernon's over there, he can tell us whether that's a problem or not, but with electronic fingerprint checks, it doesn't take any time to run them hardly.
Good. Very good. Any questions from any of the committee members? Mr. Henry. All right.
Thank you.
Thank you. Now, do we have anyone else who wishes to be heard on 1060, either for or against?
Mr. Chairman, just one point in response to that. They are actually, contrary to some belief, that some sheriffs are actually sitting down, going through these applications. They have information that maybe the probate court doesn't have, so they are actually reviewing these applications. That may take, some of that may account for some of the time that the gentleman's speaking of. So it's not always the fingerprint coming back. So thank you.
Thank you. Now, anyone else wishes to be heard? All right. We've got several amendments put forth on this. Julius, would you like to read them in clarity for us?
Sure. All right, the first amendment that I have is on line 136, where we're going to strike gun safety and put hunter education. And then line 160 through 161, we're going to strike subject to an adjudication and replace that with otherwise adjudicated in a matter. And then we're going to strike lines 281 through 366. So that's going to strike all of section 8.
All of section 8.
All of section. Right, from 281 through 366. And in section 9 on line 402, after hospitalization, comma, we're going to insert the probate court that issued the involuntary commitment order, comma. Sure. After hospitalization, comma, we're going to insert this phrase: the probate court that issued the involuntary commitment order, comma. And then line 421, we're going to strike 30 and put 60. And then line 433, we're going to strike the word closed. And that's it, Mr. Chairman.
All right. Author of the bill, did that, all of those, is that pretty well in sync?
Yes, sir, Mr. Chairman.
All right. Any further questions of the author of the bill from any of the committee members? All right. If not, what is the will of this committee? We have a motion to pass. We have a second. Now, subsequent motion. You're a member of the committee, Mr. Jaspers. Would you like to recommend each of these to incorporate into a committee substitute?
I'd like to move that these amendments as read are committed as a committee substitute. Is that appropriate?
We have a motion. Do we have a second? Second. We have a motion and a second to incorporate the language that council had read to form a committee substitute. Any questions from any of the committee to any of the amendments? No? If not, we have a motion and a second on that issue. All in favor say aye. Aye. Opposed? No. All right. All in favor, raise your hand. 2, 3, 4, 5. Opposed? And the ayes have it. Now, on the motion, back to the original motion to pass House Bill 1064 as created with a new committee sub as amended. All in favor say aye.
Aye.
Opposed? No. All in favor raise your hand. All opposed? Same vote, and the ayes clearly have it. All right, we'll report House Bill 1060 back. Thank you, Representative. Good job.
Thank you, Mr. Chairman. Thank you for your help.
Is Representative Hitchens here tonight? We have a dilemma. Representative Hitchens has got two bills. Do we have the original 0102 on either one of these? We don't. I know how important these bills are, and I know that Representative Hitchens is experienced some health problems. I know that his backup, Representative Lunston, had to leave this afternoon to go home, to go to a doctor. At the discretion of the chair, I'm going to call House Bill 1064, and somebody over there needs to flip a coin to see who's going to present this in his stead. Would that be you, Colonel?
If the chairman would allow, yes, sir.
If you don't mind, and since the representative's not here, at the discretion of the chair, what I'm going to do is we're going to hear both these bills. We don't have the 0102 copies that we've got to have for them, but if you will go over this bill, and I think we're going to see. All right, and we're going to go through these bills, and I think Frank Redunda with the Chiefs, I'm going to let you present 976. And then what we'll do is I'm going to call a meeting for tomorrow immediately upon lunch adjournment, because there will be a lunch adjournment tomorrow with the calendar that we have. And then the committee will already know about them. If there's any change to be made, then Representative Hitchens will be able to be at that meeting, and we'll move those bills forward at that time, if that suits you, gentlemen. Come on up, Colonel.
Mr. Chairman, members of the committee, thank you very much. I'm working off of LC 410746. This is House Bill 1064. In essence, what the bill requests is to give the Commissioner of the Department of Public Safety a little more latitude in allowing the use of the patrol vehicle of troopers in agency-approved off-duty police employment. As the authority exists now, there are two things that we use the patrol vehicle for, and that is DOT permitted loads and also DOT work zone enforcement. I am allowed a small lenience to contract outside of this, but we're asking for, in those areas particular where a public service is given, that the vehicle be allowed to use. And I'll give an example. A lot of the hospitals in Metro Atlanta use troopers to direct traffic in and around the hospital, and they're in the roadway without their patrol car. This presents a safety hazard for the officer that's in the roadway. It's better that the vehicle's there with the lights on, and it also has the trooper near his vehicle with all of his equipment. So if he has to take an enforcement action, he has the use of his radio, he has the use of all the things that are in his patrol vehicle. So that's just an example of what this bill is asking for, to be able to give the Commissioner discretion to allow the use of the vehicle in those agency-approved off-duty police circumstances that serve a public interest.
All right. Questions from any of the committee members? You know, you ever consider running when you're retired? You might make a good legislator, Colonel. All right. Is there anyone that wishes to be heard on this bill? Let's see what that list was. No one wishes to be heard, Colonel. You did a great job.
Thank you, sir.
And we'll be calling this one up on adjournment for lunch tomorrow.
Aye, sir.
All right. Next, 976.
Thank you, Mr. Chairman, members of the committee. My name is Frank Vincent Rotundo, and I'm the Executive Director of the Georgia Association of Chiefs of Police. I probably will not be a legislator when I grow up and retire. The LC number I'd like to work off of is the substitute LC 297009, S as in Sam. The genesis of this bill is...
If you would, the author of the bill has just arrived.
I apologize. I've been caught up in World War III.
Colonel, if I might, have you had any luck in finding the original 01 and 2? All right,
You put it in the...
Are we speaking the 01s and 02s for the new sub? Is this for the new sub for 1060?
Which bill are we on?
We're on 976 currently.
This one is 1064.
Colonel, I think Colonel on 1064. Mark, which LC number were you working from?
LC 410746, sir.
He was working from a 46, and what we've been looking at is a 0761 LC number. So what we'll need to do, Abby, for tomorrow, is we'll have to get Julius to find the, well, that would have been the older one, wasn't it? Excuse me one second.
I think the 46 one is the original bill. This is the sub to the original, adding in.
Right.
The reminder tomorrow.
I think what we'll do is we'll have council have the proper sub for tomorrow, and we'll be ready to move at a lunch break on this one tomorrow.
I've got LC 297009S.
All right, that is one for House Bill 976.
That's correct.
Colonel, go right ahead.
Essentially, what this bill does is it clarifies the record keeping for video cameras. Those of you that know that for years now, most police agencies have been using video cameras in the cars, and due to some technological upgrades, it's become a little bit easier when you can. It used to be that we kept them on videotapes, and most facilities around this state have evidence rooms that are just full of videotapes. Now they can keep them on discs and back them up. But what they want to do now is a lot of police agencies want to go to body cameras. The rule now is that you have to keep them 5 years. And what this bill would do and we worked extensively with Chairman Willard on this to make sure that we were correct insofar as the legal side was concerned, is to change it to 30 months. And many police agencies and GMA want their officers to go to body cameras, but they don't feel like they can do that unless we drop it down to the 30-month. It also puts a fee on here in addition to the regular fees for open records that it's $12 to be imposed for the copying of video recordings from law enforcement body-worn devices or devices located on or inside a law enforcement vehicle. It's a pretty expensive process, and you know, I know from experience that we spent a lot of money and had about 4, 5, 6 people working in open records just to handle a video camera request. I'd be glad to take any questions. That's the essence of the bill.
Any questions from any of the committee members before we lose any more? All right. Does anyone wish to be heard on House Bill 976? Vernon? Justin?
Thank you, Mr. Chairman. Justin Kernan, Georgia Municipal Association, and we've been working very closely with Colonel Hitchens and also the police chief, sheriff's department, prosecuting attorneys council to come up with this bill. As the colonel mentioned, many of our municipalities, especially our smaller and larger law enforcement agencies, said that their number one problem was the expense of the storage space. The 30 months, we came to that arrival because it covers all anti-litem notices, and that's the amount of time that governments have for people to notify us that we're being sued. So it would cover all notices and allow the video to be stored for an ample amount of time. We support the bill fully, and I'll answer any questions if any members of the committee have.
Good. Any questions from the committee members? No? Thank you, Justin. Mr. Barrett?
Thank you for the opportunity to speak. I'm Ronald Barrett. I'm the Director of IT for the City of Marietta, Marietta Board of Lights and Water. Our council recently approved for our police officers to start wearing body-worn cameras, and the intention was to outfit every officer with a camera. Once we went through the RFP process, we started to get down to brass tacks and to figure out what it's actually going to cost. We could actually do the capital outlay purchase. It was about $220,000 for the initial purchase, and that would outfit about 142 officers. But the subsequent storage going forward was going to kill us based on the retention requirements of today's current law. We estimate that we're at about $200,000 a year in year one just for storage after the initial purchase. And then if we have to retain that plus add to it, by year 5, we're going to be averaging about $500,000 a year just in storage costs. That will not probably take care of things like we may have to add staff to support that system, break fix, to add IT staff, and maybe even possibly add evidence clerks, depending on how many requests are coming in and how often they're coming in. So once we get to year 5, we don't really know what it's going to do. We'll start rolling video off because we'll be able to delete it, but we're not real clear on what the cost is after year 5 because we don't know what costs are going to look like out in the cloud versus on site. So we have a lot of concerns about this. So.
And what's your opinion of the bill? Just trimming it back.
It's a good step forward. I think it's going to allow us to probably implement these cameras and do it so small agencies and large agencies will have a much easier time doing this if we were shortening the retention period. So I think it's a very good step.
Very good. Do we have any questions from the lights?
Sure. I like the bill. Do you have any suggestions to address the challenges that you're speaking of?
In terms of
costs?
I don't know. I know that there was an initiative at the federal level that we looked at applying, but it was $75 million for the entire nation. I don't think that's going to cover 18,000 police agencies. Mm-hmm. I'm not sure that I'm the expert on how to finance this. We were going to do it through the general fund. We knew that also there's been a step to reduce asset forfeiture going forward at the federal level, so those funds aren't available for these types of programs. And I think it'd be really tricky to fund it through asset forfeiture after the initial purchase anyway because of the rules that surround that. So, you know, I think cities and counties are going to get into a place where they're going to end up having to raise taxes just to pay for body cams and in-car video.
Thank you.
Any other questions from any of the committee? All right.
Thank you.
You're quite welcome. Do we have anyone else who wishes to be heard? All right. What's the will of the committee? We have a motion, do pass. Do we have a second? Do you have any other questions? Any other motions? If not, all in favor say aye. Opposed? Colonel, this one's gone. Now, Colonel, before you came in, I had on 10, let's see, on 1064, I had Colonel McDonough to present this bill. It's pretty well a straightforward bill, but we don't have the correct 0102 copies for this. Now, I can, at the discretion of the chair, with the permission of the committee, we can go ahead and vote on this. You've already heard, and then we can get council to go ahead and replicate the 01 and 2 copies, but that's strictly at the discretion of this committee. Everyone in agreement? That way we can move your business forward. And I'm sure Colonel McDonough wouldn't have a problem with not meeting with us at lunch tomorrow because he didn't want to bring the Chick-fil-A's anyway. All right. What's the will of the committee? Move to pass. Any second? Second. Any subsequent motions? All right. All in favor of House Bill 1064? Say aye. Aye. Opposed? And the ayes have it. Carl? Very good.
I apologize for being late.
Committee members, I want to thank y'all for staying in, and I'm sorry, but it's just the timing of this. Thank you, ladies and gentlemen, and hope y'all will come back again.